Joining us now is John Bursch, Vice President of Appellate Advocacy and Senior Counsel for the Alliance Defending Freedom. John, welcome. Thanks so much for joining us. Talk to us about how adding 4 justices to the Supreme Court would impact the country. In what ways?
Well, it's a dangerous power grab and a blatant attempt to politicize the court. The left already gets plenty of victories at the U.S. Supreme Court, but now they want to stack the deck so that they can win all the cases. And after years of pro-life organizations pushing for politicians to make sure that those who would repeal Roe versus Wade for the unconstitutional monstrosity that it is make it up to the court. Now they're on the verge of maybe making some progress on that. The liberals want to be able to just peel all that back and stack the deck in their favor again. So this would have terrible consequences, not only for the right to life and the ability to protect, pass legislation that protects life, but also for religious liberty and free speech and a variety of other areas.
John, why do you think this push is happening right now? And ultimately, how do you think this will all play out?
Well, it's interesting that it's happening now because, as you just heard, Speaker Pelosi has already said she won't bring it to the floor. Joe Biden has said unfavorable things about the plan. Bernie Sanders doesn't support it. Even Justice Breyer, who may be stepping down soon, has said that packing the court is a bad idea. So you start to wonder, why is it introduced now? And I think one of the reasons might be to try to influence the conservatives on the court to not make rulings that follow the Constitution and the rule of law. Because if they're worried that the court might be packed, if the left doesn't like the results that they come out with, that might moderate their decisions and they may stray from what the law actually requires. And so I think it's nothing less than an attempt to influence what the justices do, and that's wrong. And I hope that the court full-throatedly rejects that with its upcoming rulings.
Changing gears just a little bit here, what else are you keeping your eye on as far as cases coming before the Supreme Court?
Well, the big one to keep an eye on before the end of June, when the term ends, is the opinion in the Fulton case, Fulton, that involves the Catholic Charities Adoption Agency in the city of Philadelphia. The city revoked their ability to place children in foster care unless they renounce the church's teaching on marriage as being between one man and one woman. There are a variety of ways that the court could decide that case. It could be a very broad ruling for religious liberty, or it could be something narrow based solely on the demonstrated religious animus of Philadelphia officials. But either way, that's going to be an important precedent for adoption agencies and for the church more generally. Depending on how narrow that decision is, Barronelle Stutzman, the florist in Washington State, who will serve everybody and express all messages but cannot participate in same-sex ceremonies by creating floral art. Her case is still waiting, and that's one that they may take up. And then another to keep an eye on are Trump-era regulations that protect the conscience rights of medical professionals, especially doctors. And those have been challenged. The Biden administration has promised to repeal them. The case is pending before the U.S. Supreme Court right now, and there's a question whether it will go forward. We filed a motion to intervene on behalf of a number of pro-life medical organizations, including the Catholic Medical Association, and we're hopeful that the court will end up taking that case and will vindicate the conscience protections of all those medical professionals.
John, we have about a minute left, but wondering if we can get any final thoughts from you. And also, are there any cases involving abortion that you also have your eye on right now?
Sure. On the abortion area in particular, there are a number of cases making their way through the pipeline, but one that's been sitting at the court for quite some time. The name of the case is Dobbs, D-O-B-B-S, and it comes from Mississippi, which enacted a law that prohibits any abortions after 15 weeks. And the cert petition highlights a conflict in the Supreme Court precedent. On the one hand, some Supreme Court cases say that states don't have the right to restrict abortion before viability. In other cases, they say that states have a strong interest in protecting that nascent life as well as the health of the mothers, and that they have that interest from the moment of conception. And what's more, the court has upheld things like prohibitions on partial birth abortions, recognizing that those can coarsen society and cause people to lose a respect and value for life. So those two things can't both be true, that you can't regulate before viability, but yet you can prohibit partial birth abortion, and that states have interest beginning at the moment of conception. The court has now reconferenced this. That's where they consider whether to grant the case at least a dozen times, and we should know in the next couple of weeks before the term ends whether they'll move forward on that. But if they do, this would be the most important pro-life case at the U.S. Supreme Court since the Casey decision many, many years ago.
John, thanks so much for coming on. We always appreciate your analysis. John Bursch, Vice President of Appellate Advocacy and Senior Counsel for the Alliance Defending Freedom. Thank you so much.
Thank you. God bless.